This is Jared Richards, and this week, the RJ is reporting that a judge has declared a mistrial in a big case against GM. In this case, Eglett, the plaintiff's attorney, was asking for, I want to say, $64 million, a lot of money for what is described as a pretty serious injury. But the mistrial, the judge has ordered a new trial, and has ordered the main attorney on the defense that attorney is not to talk in the next trial. That attorney is not to ask any witness any questions, and that attorney is not allowed to talk to the jury. And the reason for this is that attorney has violated so many court orders during the course of the first trial that the judge has said she can't trust him to say anything in front of the jury. Beforehand, there are often long hearings where the attorneys for each side identify specific pieces of evidence to the judge and tell the judge that this evidence should or should not come in, and the judge will make a ruling. Now, once that judge makes that ruling, it is expected that the attorney is going to follow the ruling. Pre-trial evidentiary rulings are often preliminary rulings, meaning that the judge is welcome to readdress it. But until that judge actually does readdress it, there is an expectation that the attorneys actually follow the rules. Now, Eglett alleges that if you watch this 5-hour period of time, that the attorney in question violated the court order, I think Eglett was alleging 130 times. The judge basically ruled that she cannot trust that attorney to have any exposure to that jury because that attorney seems to not be able to control himself. When the same motion was made against the other two attorneys, the judge said that they did violate the pretrial orders, but when an objection was made and sustained, they cut it out. Where the first attorney, objections were made, sustained, and that attorney kept on going. So years ago, we had this case against Frias. If you don't remember, Frias used to be a big cab company in town, and when that shut down, the Frias money was given into a charitable trust. And in our case, our clients were hurt by a Frias taxi cab. Now, the tactic of these out-of-town attorneys was they came in, and in every deposition, they would look at the witness and say, did you know that all of the money that the plaintiffs are seeking has been put into a charitable trust? And any money that this jury awards to these plaintiffs is going to be taken away from that charity and is not going to be used on parks and other charitable endeavors in Clark County, Nevada. Did you know that? And they were trying to hide behind the fact that they formed it as a question, that they figured they had some protection in deposition. That's when you get to ask witnesses questions under oath. Therefore, it was not objectionable. They weren't making a statement. But the judge saw through that pretty thin argument. And we showed the judge that they had done this in close to every deposition involving a witness. And so they would say, did you know that any money is awarded is going to come from a charity? It was clearly an attempt to influence these witnesses. And the judge was so enraged that the particular attorney was a female attorney, I believe out of Colorado. And she'd built her entire career not actually practicing in Colorado, but practicing in other jurisdictions. We call that pro hoc vice practice. So pro hoc vice is a limited license to practice law in a jurisdiction where you're not otherwise licensed. And her entire practice was pro hoc vice. The judge was about to revoke that license, declared that that's what he was going to do. She came up basically in tears and said, listen, this is my entire practice. If you revoke my pro hoc vice here, I have to inform every judge everywhere. And, I wasn't out to destroy the woman's career. Hopefully she learned a lesson. We told the judge, listen, we're not seeking that so long as she doesn't show up here anymore. She promised that she would exit the case, and the judge ultimately gave them sanctions, but did not revoke her pro hoc vice license because she said that she was leaving, and he took some pity on her. I find that these out-of-state attorneys that are pro hoc viceing in, because they don't have to worry about their personal reputation in a particular courtroom with particular attorneys, because they're not local, they will often bend the rules and not play nice in the sandbox, where the attorneys who practice here, well, we have to have professional relations with these judges because we're going to be in front of that judge again. And if we really piss that judge off or tell the judge we don't follow the rules, the judge is going to take that out on our clients later on. Did the judge in this case, did she make the right call? Yeah, if what is being alleged is true, I think that she probably did. Did she have the power to do it, the authority? Yeah, I think she did. And quite frankly, I think it's a good lesson. You cannot violate the judge's orders. And so I think that it's appropriate that she sanctioned them. What do you think? Do you think that's appropriate? Leave your thoughts down in the comments.